My name is Jennifer Koshan. I'm a faculty member here at the law school, and I'm very pleased to welcome all of you today to our visiting speaker event with Melina Buckley. Before I introduce Melina, I would just like to say thank you to the Alberta Law Foundation and to Total EP for generously funding our visiting speakers program, which makes it possible for us to bring people like Melina in from all over the country and internationally to talk about current legal issues of importance, not just to us here in the law school, but also to the legal community more broadly. And I'm very glad to see that there are several members of the practicing legal community here today. So, Melina Buckley. She is a lawyer and legal policy consultant who works with the firm Camp Fiorante Matthews Mogerman in Vancouver. She has a very long history of advocating for access to justice issues, human rights, equality rights, constitutional law in Canada. She served as co-counsel in numerous cases in those areas, including some major litigation at the Supreme Court of Canada. So, for example, she was co-counsel in the BC Firefighters or Marin case that I know many of you have read. She was also co-counsel in litigation that the Canadian Bar Association brought forward to try to challenge inadequate funding for legal aid. Unfortunately, that case only got as far as the BC Court of Appeal, and it ended up being dismissed. But Melina is still very active in access to justice issues in spite of the outcome of that particular litigation. She's also directed several national research projects. One of her most recent roles was working as policy counsel to the BC Missing Women's Inquiry, so she was very involved in the development of that report. She's also worked internationally in countries such as Jamaica, in Nepal, working on as an advisor on constitutional reform issues. She's involved in test case litigation in Kenya and Malawi, looking at police inaction in cases of sexual violence against girls. She's a published author in the area of equality and human rights law, and in fact has her PhD in law from UBC Law School. And most recently, she served as chair of the National Canadian Bar Association Access to Justice Committee, which ran from 2011 to 2013, and she chaired the Envisioning Equal Justice Summit earlier this year in April 2013 in Vancouver. And it's the results of that work that she's going to be presenting today. This bio is, it's kind of dry, as many bios are, and I just want to convey a sort of personal appreciation for Melina. I've known her for about 20 years now, and we've been involved together in many projects over the years, and her passion for equality and social justice is inspiring. So please join me in welcoming her to the law school.
Well, thank you, Jennifer, for that wonderful introduction, and thank you all for the invitation to be here today to talk about probably the topic that I'm the most passionate about, something that I've been working on virtually my entire legal career. And so my theme today is changing the conversation about access to justice. Access to justice is a bit of a buzzword. It kind of comes around every sort of 3 to 5 years. We start feeling as if we're making some progress in terms of actually increasing access to justice in Canada, and yet we never seem to be making the kind of progress that we all want to see. And in the past few years, the Chief Justice of Canada, Chief Justice Beverley McLachlin, has really taken the time to make this a priority issue for herself in her speeches, and I think has really created an important moment in Canadian history and created an openness in public space to talk about some of these issues in a much broader way than has been in the past. And so that makes me a little bit optimistic about our capacity to change the conversation and therefore move to a much more equal justice system. Now, often I have been doing these talks a little bit in different parts of the country over the past few months since we released our report. And often I get asked the question, well, do we have access to justice crisis in Canada today? And I can play either side of that. question, being a good advocate. But I'm really curious to start, how many of you in the room, and if you could just raise your hands, would agree with the statement, there is an access to justice crisis in Canada today? A lot more people than this morning. I don't know if that's a time of day thing or the kind of crowd that we have here. So I've kind of run into trouble in talking about this as a crisis, because when I was a fairly junior lawyer working for the Canadian Bar Association full-time, which was my first job, or legal job anyway, we started calling the legal aid situation in Canada a crisis. This was about in 1992, 1993. And of course, it's actually much worse today than it was then, so it's hard to come up with a stronger word when you start it as crisis right at the beginning. So then we started saying, well, you know, it's a crisis, but it's a silent crisis, because people don't really know. Like, until you're in the situation where you need access to the justice system and there are barriers that you can't overcome, you don't know that there's a problem. And so that's still very much the situation that we're in today, where we know, especially those of us who are more intimate with the justice system, have a sense that there's a crisis. In our report, we call the state of access to justice in Canada abysmal, made a lot of headlines, and then, you know, as it always does, sort of died out after a couple of days. So what I'd like to do is just spend a few minutes talking about the state of access to justice in Canada today, and then move on to some more positive work about ideas about how we can move forward in trying to actually address it in a way that we haven't been able to in the past. So in terms of, if I was just going to have one image to describe access to justice in Canada today, it's this image, which is a whole bunch of no-go signs, concrete barriers, and this sort of very forbidding image of something that's not at all welcoming, not at all sort of a sense that you can get the kind of help that you need when you have a legal problem. And I'd like to go beyond sort of this one image by just sharing a few statistics and a personal anecdote with you that I think sort of captures in fairly succinctly the situation of access to justice in Canada today. So I have 3 statistics. Wrong side. There, okay. My first one is kind of this funky image. It was the best I could do. So it's the 120-80 ratio that I talk about. And I think this is a really important concept for all of us to share and start from. So the first point here is that about 100% of people, so virtually everyone, will have a legal problem at some point in their lives. And that shouldn't be a surprise given the fact that we use law to regulate almost every facet of our lives now. And this is something that's been, you know, a global trend since the Second World War, where we really choose as regulators, as policymakers, to use law to regulate all kinds of relationships in a way that in the past would have been seen as outside the purview of law. And nobody is saying that that's a bad thing, but it does mean that there are going to be an increasing number of legal problems. And studies worldwide have really shown that the incidence of legal problems is quite similar in all different kinds of political systems in all different sort of countries with different levels of development. So everyone is likely to have a legal problem at some point in their lives, but about 20% of people living in Canada, so that's about the number of people who are on low income or suffer from various forms of disadvantage living in marginalized conditions. That's about the size of the Canadian population that would fit into that category. That group of people experiences about 80% of the legal problems. And the reason for that is often that one legal problem, especially if it doesn't get resolved quickly, leads to another, and there's kind of a snowballing and cascading effect. So whereas for some people experiencing a legal problem, even if they can't get help, it's annoying. Say, for example, a consumer problem, it's annoying, but it doesn't really change their lives. It doesn't really have a big impact. For other people, and particularly for people in that 20% that I'm talking about, an unresolved legal problem can actually lead to really terrible, devastating effect on their everyday life, and will have all kinds of repercussions for non-legal sides of their lives, including their personal relationships, their financial situation, their physical and psychological health, and so on. So that's the first statistic that I wanted to share with you. The second one, and I have to kind of pull these statistics together a little bit, not quite out of a hat, but a bit from here and there, because we don't really have a central repository of knowledge about the state of the justice system in Canada, and particularly about access to justice in Canada. And this lack of data is one of our problems, I would suggest, in terms of moving forward, and I'm going to come back to that later on. And so when we're trying to make the case for how bad the situation is, we can't really ever even quantify. Has it gotten better in the last 5 years? We have a sense that it's gotten worse, but we don't really have any numbers that help us to substantiate that. What we do have from anecdotal evidence from judges and lawyers and so on is that there's been an incredible increase in the number of unrepresented litigants in our courts, particularly in terms of family law matters. And whereas about 20 years ago, there was about 1% of people were unrepresented in family and civil legal matters, today it can vary from anywhere from about 10% in a given court in a given year to about 80%. And that 80% comes from either small claims court and then some family law courts in parts of the country. So just a huge rise in terms of unrepresented litigants, with all kinds of repercussions for both the individual and for our justice system overall. And the third statistic that I think is really important that we know about, and I think we should really spend some time publishing, is how we rank internationally in terms of access to justice. And this is an issue that the Chief Justice, again, has really spoken about quite a bit. There's an institute in Washington called the World Justice Project, and it has created a form of measurement of the rule of law. And so the rule of law, they measure in terms of various indicia, including whether there's free press or the degree to which there's a free press or open media in a country, the lack of corruption, strong anti-corruption measures, free and democratic elections, and so on. But one of the important indications that this group sees as being part of the rule of law is access to civil justice. And so whereas Canada fares very well on all the other indicators that I just mentioned, in terms of access to justice, we fare quite poorly, and we're about 9 out of 12 out of other high-income countries that this group takes a look at. But what I think is even more telling, and a statistics that's not very often reported, because you have to go through sort of their deep tables about how they come to that 9 out of 12 ratio, is that on access to civil legal services, so in non-criminal matters, we rank 54th out of 66 countries in the world. So that means that we rank lower than all of the other high-income countries, including the United States. We rank lower than most moderate-income countries and some low-income countries that have chosen to really prioritize access to legal services in a way that we haven't in Canada, at least not for the last 15 years or so. So I think that that's something that we should really think about. What does that mean about us, about the choices that we're making as a society in terms of what we invest in and where we don't invest? But of course, numbers don't tell the whole story, and so I'd like to share with you, this is sort of an image of a frustrated litigant trying to get into the justice system. I'd like to share with you the story of Amanda. And Amanda is a woman, lives in a medium-sized community in Saskatchewan, but she could really live anywhere in the country. Her story is, I think, very typical of the kinds of stories that the CBA committee heard about during its consultations, as well as other studies carried out by, for example, Julie McFarlane from the University of Windsor, who's really published, I think, sort of the leading study of the experience of self-represented litigants to date in Canada, as well as some other studies that we took a look at. So Amanda has had what was, a very, in some ways, very traditional life story, married just out of high school, had children very young. Her husband was the main breadwinner. She started to work part-time once her children were in school, but for minimum wage and part-time, so not earning very much money, certainly not in a situation to be financially independent. One day, her husband comes home and says, I've had enough, I want a divorce, I'm moving out. And so, of course, she was floored emotionally by this, as anyone would be, and is dealing with this as very much a personal crisis. But she also has no idea where to turn, what to do in terms of the legal situation. So she applies for legal aid. She tries to apply for legal aid, and the legal aid office won't even take her application because she doesn't fit into the categories of legal services that they're providing because of cutback. So she can't even get to their front door. She doesn't even become a statistic of the people who are denied legal aid. We don't even, gather information about her. She then borrows money, as many people in this situation do, from friends and family, so she can have access to a few hours of a lawyer's time, and she finds this very helpful. But because they canvass some opportunities for early resolution or mediation, doesn't look like that's going to be possible, it's going to go to trial, and it's very clear that she can't afford to do that, even at a relatively low rate that the lawyer is prepared to charge. So she feels like, well, I'm an intelligent woman. There are a lot of resources online and various kinds of written materials. I'm going to do my best and represent myself. I have to. I have no choice. And she starts off, she describes to us that she's quite optimistic about this. She feels like she can sort it out. But then after a time, as she tries to pull together her case and pull together the evidence that she needs and deal with a lawyer who's representing her husband, that it really becomes a full-time job for her to try to just prepare for her time in court. And so because that becomes her full-time job, she has to quit her paid employment, and she then starts to collect unemployment insurance, and eventually, when that runs out, social assistance, as sort of this case moves through the courts at its usual pace. And she also describes to us that she feels her ability to parent is affected because she's under so much stress. She's spending so much time preparing for the case, and that starts taking a toll on her physical and emotional health. So already we can kind of start to see some of the societal costs that are accrued by the fact that she can't get effective access to justice in the way that she needs it. So she finally makes her way to her 3 days in court and finds it to be just the most devastating experience of her life. She says to us, she uses words, very strong words, like, I felt like I was drowning, or I felt like I was in a room where the judge and the lawyer on the other side were speaking a language that I didn't understand, and that she really felt like very much an outsider, just being permitted to be in the room, but not really having a chance to present her case in the way that she kept making mistakes and being called on it and so on. And this is, I think, a very typical, not the only, there are definitely some more positive stories, but it's very typical in terms of the way many unrepresented or self-represented litigants describe what they feel like when they are trying to navigate the system. So the outcome is kind of a mixed outcome, as often is the case with these difficult family law matters. So she's able to retain custody of the children, which was her priority. But on looking at her case from an objective outsider's perspective, there's no question that on the financial side of the marital breakdown issues, she definitely could have done a better job or had a better outcome if she had been fully represented and been able to avail herself of that knowledge and those opportunities. So mixed, terrible process, kind of mixed outcome. But then I think probably the most surprising and the most telling part of what she told us is that this continued to affect her for quite some time after after the history of still months and even a year later after this had happened to her. And she's one of the people who coined the term post-court traumatic stress disorder. So this idea that there are kind of long-term repercussions, still like sort of nightmares, and still some sense that she was unfairly treated. She didn't receive justice because of the fact that she didn't have adequate legal assistance. So we can see from Amanda's story, and then the other side of it is that the case took a lot longer in court than it would have if there had been two represented parties. And so there's obviously some frustration on the part of the judge and the lawyer on the other side because of that, because she would take longer to present her case, would not know sort of the rules of evidence and so on. So we see that aside from this tremendous personal cost that Amanda has borne because of inaccessible justice, we see that there have been all kinds of repercussions from the system, both within the justice system and then within our social welfare system overall. And of course, Amanda's story is not by any means unique. It's happened to Pierre and Nadine and many people across Canada, and those stories are sort of piling up on top of each other. And it really just leads us to think, why is it? Why is that being allowed to go on? And then the Canadian Bar Association's committee, and I think Jillian Marriott, one of the members of my committee, is hiding at the back there. So thank you for being here and for all of your work on the committee report. What we wanted to do is we also wanted to find some way of reaching out to the public more generally to get the sense of the public perception about access to justice in Canada. And so we held a number of focus groups. Jillian helped organize 1 or 2 here in Calgary, and we held them in various different size communities across Canada, focusing particularly on groups of people who are low income, are living in more marginalized conditions, the kinds of people that don't always get asked questions in regular surveys. So we really tried to focus on them. As well, we did on-the-street interviews with people, just kind of quick ones, with the assistance of pro bono law students in different jurisdictions to help us do that. At the same time that the CBA committee was doing that, the Canadian Forum on Civil Justice did a very similar project, quite interesting. We hadn't talked about it, but and then so we were able to gather the findings of both those 2 initiatives and bring it together in our report. So these are some of the things that we heard, or these are the themes that we extracted from all the various things we heard. So first of all, the biggest problem that people identified is that justice systems are difficult to navigate. Many people couldn't, when we said, well, what would you do if you had this kind of legal problem? We got a lot of blank stares, a lot of like, I don't know, some people said I'd go to the police even though it was a criminal, civil law matter, or they'd go to their parents or their doctor. It was a very difficult question for people to understand, and those who had experienced a legal problem really talked about how difficult they had found taking just those first few steps. And in some instances, people talked about just giving up because the justice system was so difficult to navigate. The other theme that we heard very clearly was this idea that legal rights are just on paper, and especially if you don't have money, you're not going to, they were basically meaningless. Another theme that was a little bit surprising to us, and I think is something for a bit of reflection on the part of the judiciary and the legal profession in particular, is that justice is person-dependent. So people's experiences really vary depending on which judge they got, which legal aid lawyer they got, which private bar lawyer they got. And there was a sense that it was really hit and miss, that there was no consistency in the way justice is delivered in Canada today. And then finally, this was kind of more of a minority view, but still a very important theme that we heard, is that because of all this, justice systems cannot really be trusted, and a lot of people have just given up and won't even take the first step. So that's sort of the depressing overview of the state of access to justice in Canada. So this is one of the ways that I like to just summarize sort of the 50 pages that we have in our full report about the state of access to justice in Canada. So we live in a world that is thick in law and thin in legal resources. So we put a lot of emphasis and energy into making sure that our laws are sound, revising them, doing a lot of good work in that area, but we really underinvest in the legal resources. And so our response, the CBA committee's response to this quote, which is from a US academic, is that we need to radically redress this balance. So we need to start thinking about, whenever we're investing in law, whenever we're using law to regulate social relations, we need to be at the very same time thinking about how are we going to ensure that there's access to those good quality laws to the justice system, and how are we going to make sure that there's actually equal access to the justice system. So having decided that that's sort of the framework that we need to respond to, we came up with the CBA report, which the title is actually Reaching Equal Justice. And we tabled a summary version of it in August, and our full report is actually expected any day now, probably in the next week or so. And we're very excited about that. But really, all of the themes, all of our main recommendations and so on are in the summary report. What will be in the full report, which will be available on the CBA website, is a lot more discussion about how we came to the conclusions that we came to, a lot of links to resources for people who are actively engaged in this area, and that type of thing. So I certainly encourage you to take a look for that when it is available. So when we started doing this work, and we know that there are a lot of reports on access to justice. I've written a few of them myself, so I know that they're there. And we know that a lot of good people have been doing a lot of good work and thinking hard about these questions for some time. And yet, as I said at the beginning, we feel like we're not really making progress. So when we started our initiative, we actually spent quite a bit of time brainstorming about why is that? What are the barriers to actually moving forward with ensuring equal access to justice in Canada? And we came up with 4 barriers that we were really trying to address in our work in envisioning equal justice. So the first one is that there's a lack of public profile and public engagement around access to justice, right? There's a bit of a disconnect between the Canadian public at large and the justice system. Secondly, there's inadequate strategy and coordination amongst the various players within the justice system, so that someone over here is making a good change, but because they haven't talked to these providers over here, there actually can be negative repercussions, or in some cases overlap or duplication of resources. So we don't have enough strategy and coordination amongst the various players within the civil justice system. It's a very diffuse system. We have no effective mechanisms for measuring change. So as I said at the beginning, we can't really ever say whether things are getting better. We're not actually very good at measuring whether or not a change that we've made is effective. We have started, definitely in the last decade, doing a lot more evaluation in this area. There's no question about that. But there are still big gaps, big holes in terms of our knowledge about what is effective. And then finally, there are some problems that we just need to work on more. There's still gaps in our knowledge about how to fix some of the problems within the system. So we were hoping to at least take some steps towards addressing all of these barriers in our report and in our work following up on the report. But we thought we really needed to start, first of all, by envisioning what we wanted to see in the system. Right? It wasn't enough, we thought the problems are too deep and too broad and too extensive to just sort of think about what could we do easily here or over here. What are the quick fixes? We felt that really we were beyond that, and that we would not be able to achieve our goals of equal justice if we didn't really take a step back and envision where we wanted to end up. So we started off from the premise that 100% access is the only defensible goal. Now this might seem really uncontroversial, and everybody say, of course, that's what Canada is all about. We're all about equality. It's very much as part of our DNA. But the reality of the access to justice conversation in the last 10 or 15 years, within the context of growing scarcity of public resources, has been all about rationing, and all about the fact that we can't afford justice and we need to just kind of make do. And people are really worn down by that and have kind of bought into that a little bit. And so the CBA committee really felt like we just needed to start with that proposal and always be asking ourselves, who benefits from the reforms that we're bringing in, right? Who, this whole shift in moving towards internet-based or web-based resources, who benefits from that and who can't take advantage of that? And is it maybe the same people who are having overall problems in accessing legal services are also having problems in accessing web-based information services? So are we not maybe in fact just replicating the problems in the way we're making the solutions? So unless we're asking those equality questions, we're probably just going to contribute to the problems. So we felt that was very important to say that and say it loud and say it a lot. And so you'll see that repeated quite a bit in our report. The word equality is quite frequently there. In terms of where we want to go, we really did this as kind of almost a brainstorming around what ifs. Like, what if we were starting from ground zero to develop a really accessible justice system in Canada? What would we want? And what does the literature, what does the research, what does the empirical research tell us would work well? So we can phrase this as a series of what ifs. Right? What if we had a system that really put the people with legal problems at the center of it, rather than setting up a framework that really works towards the advantage of the way judges and lawyers have always done their work, or just doing what we've done because we've been doing it for hundreds of years? Like, what if we really started from what people say they want from the system, what they need, what actually helps them? What if we could create a justice system that is easy to approach with lots of front-end help? Right? That's what we know for sure will help people and is probably one of the most effective steps that we can take. What if everyone had access to the type of legal service that they need, depending on their social situation, their capacity, the seriousness of the interest at stake, and the complexity of the procedure that their legal problem takes them to? So what if we were really able to immediately kind of figure that out, provide the service that was necessary? Now, when I say that there would be access to legal services in every case, I don't mean that there would be a lawyer or access to services from a lawyer in every case, because we really need to be developing and providing legal services, in a much more team-based approach. But it does mean that when a lawyer is needed, that individual would be provided with one, regardless of their financial capacity. So it's not a lawyer in every case, but it's a lawyer in every case where a lawyer is needed. What if the justice system would work in a way that's really tailored to people's problems, so that it's not one procedure that you have to go through no matter how complex or how much money's at stake, or any of the many variables? What if we really had justice made to measure? What if courts continued to play a central role but were much better integrated within the overall civil justice system? What if we broke down the silos between the justice system and other types of service providers? Because we know that when people are experiencing legal problems, there are other dimensions to these problems, right? As I mentioned before, there are financial issues, there are social issues, health issues, and so on. So what if we actually helped people to develop lasting outcomes for the legal problems by addressing all of the related issues and provided services in a way that broke down the silos of the way we work now? And what if we really committed to justice innovation, to supporting that, to really having a well-developed research and development program in the justice system across Canada? And what if we shared that information both amongst service providers, but also with the public, so that they felt that they were engaged in that process as well? So by answering all those, what ifs, that's what we think it will take to reach equal justice. And we said in our report a target of reaching equal justice in Canada by the year 2030. And we've had kind of mixed responses to this, right? Some people say, well, I'll be dead by 2030, so I'm not going to do it. It's way too long a time horizon for some people. But we think we needed to do that because we felt it is very much a long-term project. It's probably even an ongoing project beyond 2030. But we wanted to set some measurable targets. And in fact, in our report, we have 31 targets that range. Some we say should be achieved by the year 2020, some by 2025, and some by 2030. And then by 2030, we'll probably have another set of, but in setting up these targets in a way that we've tried to define them, in fairly concrete, measurable terms, we'll be able to know whether we've achieved what we've set out to achieve. In addition to having the 31 targets, we have milestones. So how will we know, 5 years from now that we're on the right track to reaching those targets? And then we have some immediate actions for people, so that people don't feel like, oh, they just have to now figure out how to get to that target by the year 2030. We have just kind of indicative. We obviously couldn't list all the actions that it would take over, a 17-year period to get there, but we at least wanted to say, okay, well, these are like 5 things that we think could be started right away, that we have the capacity to do right away. Many of them don't have dollar signs attached to them. Many of them are about just working differently or investing a little bit of money in specific projects and so on. And we say, okay, well, these are some ideas of the immediate actions that could be taken, and there are going to be a lot more. So what I'd like to do now is spend a little bit of time telling you about, or giving you some examples of some of the targets and some of the actions that we recommend in our report. So I've mentioned that our framework is that we want to reach equal justice by the year 2030, and so our way of bringing together all the various recommendations that we make is by this bridge, the bridge to equal justice. And our bridge has 6 parts, and I'm going to talk a little bit about each of them. So the purple, the yellow, and the red lanes are sort of the lanes on the bridge. So these are the major strategies that we feel need to be undertaken in order to really create an accessible justice system in Canada. And then, we say that most reports just talk about those kinds of things, just talk about those practical strategies of what we need to do differently. And because we are addressing the barriers that I outlined a few minutes ago about why all the good reports, all those good ideas haven't worked so far, is because we say there hasn't been the kind of support structure that the bridge needs. And so then we have 3 elements of our bridge that are really supporting this work in an ongoing way. So I'm going to just speak briefly about each of these. So I'm going to do these 2 together. The first one is facilitating everyday justice. So the idea of everyday justice is that most of the legal problems that people encounter will never, ever reach a court or an administrative tribunal or other formal dispute resolution mechanism. Most of them can be resolved fairly easily, fairly quickly, if the right kind of help is provided. And so a big shift in the way we think about access to justice has to be in terms of investing in this kind of resolution of everyday problems or informal justice. And we have a number of recommendations about how to do that in the report, and I'm going to highlight a couple of them. So first of all, we set as a target for the year 2030 the idea that 5 million Canadians will have been given legal capabilities training. So one of the points we make in our report is that law should really be seen as a life skill, just in the way that we should all learn to, when we need to go to the doctor, that we need to go for our annual checkup, we need to take responsibility for our health, we need to take responsibility for our financial health by doing various things, by learning how to budget our checkbooks and so on. We also need to understand the role that law plays in our lives and sort of some of the risks that we encounter just, as we grow up and go through the various steps in our lives. So we talk about the importance of law as a life skill, and we make recommendations about the kind of training that should go on starting in public school and and then also being provided at various transition points in people's lives. And right now we do provide certainly a large amount of public legal information, and education is available. The difference with the kind of training that we're talking about is it's not just the transfer of substantive knowledge, so what to do if you have a family law problem, what your rights and responsibilities are under a given law, but how you can equip yourself as an adult citizen to take responsibility for legal matters. And so we talk about the kinds of skills that we can help people develop and the kind of attitudes about the justice system that we can develop. And there's quite a rich literature, especially at the international level, on how to do that. So when I say skills, I mean things like listening and communication skills, some of the things that are taught in law school. So some skills of analysis, of trying to identify issues and interests and so on. So some of those skills, so this is not at a time when people are dealing with a legal problem, it's at a time when they're sort of not in a crisis mode, not under a lot of stress, when they can really learn and integrate these skills into the way they approach their everyday lives. So that's one of our recommendations, just to give you an idea, and then we have specific actions that in particular the CBA and current public legal education providers and so on can do to actually try to achieve that goal. And it obviously means working with the education system and so on. The other idea that we spend quite a bit of time talking about in the Facilitating Everyday Justice session is this concept of legal health. And we say that by the year 2020, the idea of a legal health checkup should be routine. We should all just, have this checklist that once a year or once every other year we go through, we make sure all our legal papers are in order. We think about, has anything changed in our lives that may trigger a legal need? So again, it's kind of a risk management, risk analysis. We talk about how we need to think about legal health not just at the individual level, but also at a systemic level. So what is the legal health of our community? How could we measure that? How can we identify recurring problems that are maybe clogging up the court system or administrative tribunals and actually deal with the root problem so that we prevent that whole category of cases? So, very kind of transformative thinking, I think, about how we could be approaching access to justice. The second lane of the bridge that I showed you, the red one, is transforming formal justice. And here we're talking about, so what should courts look like by the year 2030? And we talk about how courts should be recentered within the justice system, that courts should still play this very important role, but that there should be much more of a fluid relationship sort of in and out from the court system to the civil justice system more broadly, so that we would see referrals from the court to a greater extent than potentially right now, mediation and so on, or that if you're in a mediation but you need a quick resolution of a legal issue in order to move forward, you would have that kind of quick access. So just a much more integrated system. We talk about generally sort of the global developments and where courts are going and what we've learned at the international level about what works. And so a few of those things are a greater degree of court specialization than we have generally in Canada today, other than in Quebec, and some other examples. We talk about how dispute resolution processes have to become much more tailored, moving a little bit away from the rule-based emphasis that we have today, and a lot more emphasis put on actually triage and referral based in the courts themselves. So just a few highlights there about what we talk about in the report. The third lane on the bridge is reinventing legal services delivery. And not surprisingly, since this is a Canadian Bar Association report, we have quite a bit in this area. And there's definitely a focal point because it's an area where the CBA has a particular responsibility in order to ensure that we're providing or that we contribute to the provision of legal services in the best way possible. And so our targets and our recommendations here really touch a large range of issues, and I'm not really going to be able to talk about them too much, but I'm just going to say a few things. So we talk, first of all, a little bit about cross-cutting or overarching issues about the way lawyers provide services. And we say that there are two big important changes that have started in the last decade or so, but are going to really pick up speed and have the potential, if properly implemented, to really contribute to equal access to justice. So the first one is limited scope retainers. This is the idea where that a lawyer comes in just to do one piece of the work rather than being responsible from beginning to end. It's a great idea in theory. There are a lot of issues about how to implement that in a way that is consistent with our responsibilities as member of the profession, that there are lots of issues around communicating the limitations of that with clients, ensuring that we're getting the kind of consent that we need and so on. There's a lot that law societies and the CBA can do to really help ensure that that is implemented in a way that creates equal access to justice, and again, conversely doesn't contribute to unequal access to justice. The other really important one is this idea of team-based legal services delivery. So just as the medical profession has really moved towards a team model, where there's greater specialization and greater specialization of other types of professions, so registered nurses and so on, that are doing work that traditionally maybe a doctor would have done, or in a dentist's office, the same thing. It's very much segregated. Different people in the office are doing different parts of the work. That's the direction that legal services are going in. And we talk a little bit about that in our report. We also talk about how lawyers need to work with other service providers to a much greater extent than what happens now. Particularly important in the legal aid context, but also we would argue in the private delivery of legal services, where we're talking about personal law services, so developing or providing legal services to people, not businesses. But then we also talk about some systemic changes that need to happen. And a couple, I think, that are particularly important. One is really promoting the idea of legal insurance. This is something that has really been effective in European countries in terms of evening out the gaps in access to legal services. There's been some work done in Canada out of U of T, Professor Michael Chabilko and others, about how this could be a mixed public-private investment, so people could pay a relatively small amount, usually as a rider on their house insurance or their car insurance, and be covered for at least a certain range of legal issues. But then also there could be some public money put into that to make sure that the coverage is more uniform. So a lot of important work still to be done ahead of that. The CBA has already started working with the major legal services provider here in Canada because there are gaps in coverage, and most importantly, there's no coverage right now for family law matters. And so, that's obviously something that we're trying to do whatever we can to get the insurers to cover that. And in terms of what else we see for the private delivery of legal services, and I think this is particularly important to the law students in the room, is that we need to find ways as a profession to support the development of new kinds of law firms or law entities that can deliver affordable legal services to individuals. And one of the most optimistic or positive sides of the work that I've been involved in over the last 2 years with this initiative is talking to young lawyers who really want to do that. They're saying to us, we don't need to make the big bucks. We want to be able to live well, decently, but we don't like the dream, the big law firm dream, the business-driven dream, but we don't know anymore how to set up or how to run a law firm that can provide those kind of services at a rate that people can pay. And so there's quite a bit of work that I think we can do as a profession overall to support those groups of lawyers, to enable them to start up these practices. And there's been quite a bit of interesting work in the United States. They call it incubating law firms. incubator law firms, where bar associations and law schools and so on help, by providing, for example, paying for the support services or helping just with forms to set up the firm and marketing strategies and all those kinds of things, common things tools that we could provide to young lawyers and other lawyers who are prepared and really want to do this work, but feel that they don't have the business models that they need to make it work. On the public side, we say quite a bit about legal aid, and this is something that I've spent a lot of my personal time on. And we talk about the need for national standards in legal aid, both in terms of the coverage of issues, who's eligible, and then we talk about the importance of delivering legal aid services in a way that's cost effective and is holistic and follows all of the recommendations that we make in the report. So quite a bit on that. And then we talk about, so we're going to reform as much as we can the private delivery of legal services. We're going to ensure that we're investing properly and providing public legal services or legal aid in the best way we can. And we say the ultimate goal is that between those two types of service providers, with like the legal insurance support that I talked about, we should be able to have no gaps in the provision of essential legal services. And so because of that, we say that pro bono, which has been increasingly playing an important role in terms of the delivery of essential legal services, should then be able to provide the next level should be freed up to be able to spend time on the other level of services. So things that aren't quite related to fundamental interests, but nevertheless are very important legal issues that people need help with. And we give a few examples of that in the report. So in terms of our recommendations about pro bono, we say yes, every lawyer in Canada should at some point in their career provide pro bono. They should just do that as part of their professional responsibility. There are lots of good reasons to do that, but we don't believe that access to essential legal services should be dependent on that volunteer commitment. So we say by the year 2030, we should have fixed the other ways that we provide legal services enough that we have found a new role for pro bono. So that's, and then we have quite a bit about the role of law schools and law students as also being an important part of that picture, and we really argue very strongly for much stronger clinical legal education in law schools as being something that we see as a priority and a small but nevertheless very important part of the access to justice picture. So those are the highlights of the three lanes. Now I'm going to have to go fairly quickly through the support sort of structures because I want to leave enough time for discussion. The first support structure that we have is public engagement and participation. So we say that without having more public participation and engagement in the justice system, we will never reach equal justice. Because right now there's, as I say, this disconnect between people and the justice system. And so as a result, there isn't the kind of groundswell support that's needed to reinvest in the justice system. And so we need to find a way of including members of the public in this discussion about access to justice. And we need to convey to them the important reasons about why they should care about equal justice. And we have quite a few recommendations in the report about how to get to that. The second support structure that we talk about is the need to really build more collaborative and effective ways of working together, different forms of leadership that work to cross sort of the boundaries, the silos between the various parts of the civil justice system. So one of the most colorful sort of ways of talking about the civil justice system is that it's like a body without a brain right now. So you have like arms and legs doing various important things, but there's no overarching coordination. And it's very difficult to get that because each group within the justice system is independent, and there are very good reasons for that. Obviously, we need to respect judicial independence. We need to respect independence of the bar, as well as the role of government, understanding the role of government and the independence of that role. And yet, because of the independence of those actors, we haven't been able to develop the kind of structures that we need to make sure there is a coordinated effort. And so we talk about the need for ongoing collaborative structures, not just the occasional ad hoc committee that's working on a project and then disbands, which is kind of the typical way that we do things today. And we canvassed two ideas about how to work towards that. One is the American model of access to justice commissions, which are usually chaired by the Chief Justice of a given state. And these are basically volunteer committees. Sometimes they're set up actually by legislation, and so people are forced to do it. And it doesn't. Sometimes it comes up from a more grassroots or strong sort of judicial leadership, and that's the model that is quite popular. It's something that would be relatively easy to implement. But the CBA report basically says we don't think that's enough. We think that's a necessary element, that there should be ongoing access to justice commissions. They really have to fit the local community. It's probably more at a local level than a provincial level for them to be fully effective. Or more accurately, probably you need both provincial and local committees, especially in a province like Alberta, where the issues might be quite different in Edmonton and Calgary, just to give those two examples, not to mention in the smaller, medium-sized centers. And so we argue in the report that we need something beyond these access to justice commission. We really need a person or a small group of people whose only responsibility is to ensure that there's access to justice. And we call that, access to justice commissioners, because that's the model that we have in Canada. A commissioner is a body that doesn't have legal authoritative power over other bodies, but has very strong sort of moral authority, persuasive powers to make change. And so we think that a small body that was invested with that responsibility and a little bit of resources to do that and really focused on it full time would really be able to bring the various efforts that are happening and those that are going to happen in the future together in a sustainable and sustained way. And then the last aspect of our bridge is this need to build the capacity for justice system innovation. So justice system and innovation are not words that you often hear put together, right? We're a very tradition-bound culture, and most of the reports that have talked about the difficulties of justice system reform have talked about the need for culture change, and that you can't just change the rules, you need to change the behavior of people and that kind of thing. And so we in our report talk about ways that we could build this capacity for justice innovation. And we say, first of all, that it requires an extensive ecosystem that nurtures the process. Right now, we really have people that are working, trying to do innovation on the sides of their desk without any resources, without any centralized support, and we think that that is really a detriment to the possibility of us achieving equal justice. So we have a number of recommendations in this area, the foremost of which is that we should have a national structure of some kind that is really just focused on justice system innovation, that is able to do the kind of evaluative research that we've talked about and make sure that it's shared across Canada. We talk about the importance of a renewed role for the Canadian government, for the federal government. There's been no question that part of the downgrading of the justice system has been because the federal government has pulled back in areas of legal aid and some other areas. This is not a new refrain for the CBA, but we're trying yet again to make that plea, and we make a few arguments for that. We talk about the importance of having more research on a national research agenda, again speaking a lot to law schools, but not solely to law schools, about the importance of that and really finding ways of fostering that research in a way that it hasn't really caught on to date. We talk about the role for the CBA within all of that as a national organization, and the need to really come together and agree on ways to measure access to justice in terms of some national indicators that maybe could have some differences for each province and territory. So that's basically the full bridge in a very, very synopsized way. And I have a feeling, at this stage, you're all sort of sitting there going, oh my God, I can't believe what she's talking about. It's so much work. It's just a mammoth amount of work. And you could even say that it was elephantine. This is my favorite image of my slideshow. And the idea is, that moving to action doesn't have to be as scary, as overwhelming as, it may feel based on what I've just presented to you and all the detail and all the different areas, all the hard work really that lies ahead of us. And so the old adage that came to my mind was, well, how do you eat an elephant? One bite at a time. And I'm not suggesting that we eat elephants at all, but that we need to keep this big vision, the whole elephant in mind, but that we need to take small steps, small bites that are within each of our capacities to do. And so that's very much the way we framed the report. We coined the phrase, our report is an invitation to think systemically and act locally. So playing on the phrase of thinking globally and acting locally. So think about the whole vision that we've provided to you, or maybe the vision that we've provided will change a bit as we move forward with dialogue and discussion. But think about that whole picture while knowing that you can just do a small part of it, but that it will be a lot more meaningful and has a better chance of leading to concrete change if it's within this whole bigger picture that I've tried to describe to you. So part of our hurdle in moving forward, and this is the part that I think that each of us can play a role in wherever we sit, whether we're law students, members of the community, judges, anybody who's in this room and anybody who's outside of this room, is to try to overcome the fact that justice has really taken a back seat in Canadian society, right? It's really, it's not on the pedestal that it was on earlier, and it's really lost ground if you just look at it in terms of funding relative to other areas like health and public education. And we have some of those statistics in our report. So for example, for every $40 that we spend on healthcare, we spend $1 on the justice system if you don't count policing and corrections. So 40 to 1. Now I'm not saying that I can tell you what the ratio is, but I think just knowing that 40 to 1 ratio should raise some questions about whether we need to shift some things, especially when we know that spending some money, and we have very clear evidence on this, spending some money on justice, preventing legal problems or resolving them early will actually save money in other areas of public spending, especially health. So the problem is we don't budget that way, right? We can't actually see the impact between putting a bit more money into justice and saving money in health. The connections just can't be drawn closely enough in a way that impresses Treasury Board anyway to make some changes around that. And the reason I say that we know that we can save money by investing in access to justice is that from studies outside of Canada, we know that for every dollar spent on legal aid, we save $6 in other areas of public funding. And that's just the average. So some studies have shown a much higher ratio, some it's more like 1 to 3. And so we just took the average of that, and that's the overall figure that we feel quite comfortable with. So two, I think, important numbers that we can use to throw out in trying to change the conversation around access to justice. So I have, in our report, we talk about some of the ways that the conversation around access to justice needs to change. Right now, it's a little bit of a finger-pointing exercise, often, with politicians pointing to judges saying they're too expensive and are too worried about having nice offices, and that's why, we don't have enough money for justice, or it's judges saying, pointing their fingers at lawyers and saying it's lawyers' fault, and we, lawyers point our fingers at everybody and blame everybody else. And so we have to move away from that kind of finger-pointing exercise to really trying to figure out how we can work together and how we can engage the public in a way that is encouraging, because I think until we get to a point where people really feel that it's their justice system, not the system that belongs to judges and lawyers, we never will make the kind of changes that we need to make. So we make a few arguments that I won't go into, but they basically boil down to one thing. We need to replace the mantra that's very popular now with government that we can't afford justice, we can't afford first-class justice, we can't afford Cadillac justice, whatever probably outdated analogy that is thrown around, and because it's just too expensive. And we need to counter that by saying, in fact, we know that a healthy justice system is very important to economic growth. There's absolutely no question about that justice is a value in itself, that we can't just reduce it to dollars in that way, and that justice is a very good investment. And we have various kinds of arguments about how to do that. So now, just sort of as I move to the close of my presentation, I'm going to shift to you a little bit and ask you to think about what role you might play in changing the conversation about access to justice in Canada. And I want to throw out a few ideas of easy ways that each of us in this room could go out tomorrow and make at least one step towards changing the conversation in the way that I say it needs to be changed. So this is all of us here, and this is at least one of you holding your hand up saying you're going to do one of these things that I'm going to recommend. Pretty cute, eh? Okay, so the first one that I'm going to recommend is become a champion for legal aid. So how would you do that? Write a letter to an MP or an MLA and follow up. Ask them, where they stand on increased funding for legal aid, whether they're prepared to take any steps for that. If you don't want to do that, or you think that's not really going to lead anywhere, just have a conversation with someone in your community or even in your family about the importance of legal aid. See what kind of reaction you can get and see if you can move them to become engaged. The second action that I recommend is become a justice innovator. This is particularly important for people who are practicing or are delivering court services or are judges. How do you shift to really embrace change, to move from this mentality that, oh, that's a good idea, but we can't do it, to a yes, and we can do it. How do we do it? How do we start moving the shift to investing a bit more in research and development in whatever legal environment you work on? Maybe actively participate in a local reform effort. And when a rule change or some proposed change comes, try to be open-minded about it. That's fundamentally what being an innovator means. Another maybe more interesting step that you can take is just promote this concept of legal health. Talk to your family about having an annual legal health checkup. Go online and find, there's various checklists you can find online. Just do it yourself and see what happens, and then maybe talk about that with a few people. You can spread the word about either what some of the things I've talked about today, maybe that have stuck with you. Just, again, start up a conversation, maybe not about legal aid, but about one of the other facts that I've thrown out today, and see what kind of reaction you get. What we found in initiating conversations in various different forms is that people are really interested in the justice system and are really, do have strong views and want to talk about it. And so we need to create more forums where we can get people engaged. And then the easiest of all is just inform yourself. If you haven't had a chance to take a look at the CBA report, take a look. It's pretty short, and there's kind of a cheat sheet for those of you who want the really short version. There's like a roadmap to change. It looks kind of like a subway map to me, and it just has all of our targets leading towards equal justice. So even if you're just going to take one step, this is available on the CBA website, and I couldn't get it on a slide because it was too much information. But just take a look at that and see what you react to and what you want to learn more about. Of course, the CBA is not the only group doing work in this area, and the National Action Committee, which is chaired by the Honourable Justice Thomas Cromwell, has also released a report that the CBA was involved in. That's another important source of information and ideas about what can happen. And then, maybe you think everything I've just suggested is boring and you have your own burning idea about what you could do, so definitely go out and do it. And if you want to, please tweet, the CBA #A2J and just say, this is what I did today for access to justice. Or, send in an email to the CBA so that we can get these ideas going and this conversation going. So in closing, it's the right of everyone in this country to have access to justice. And that's up to everyone, all of us, to repair and evolve the system so that that becomes a reality. And I believe that our individual and collective efforts will help us to achieve equal justice by the year 2030, and that our legal system and our country, our society, will be the better for it. But it's only going to happen if we each take a step forward, thinking systemically and acting locally. So that's all of us moving towards equal justice by the year 2030. And I think, some of you, I'm worried, may feel like, well, I'm really glad that the CBA committee is doing that, and makes me, I can it's a load off my shoulders to think that someone is doing the work. But it's not enough. We really each have to be doing our own part. And I want to sort of impress that upon you with this quote that I think really captures the situation well, which is, if not us, then who? And if not now, when? And I think this is a very critical moment in terms of the Canadian justice system, and it really depends on all of us to take our part. And in just taking out one last page from the CBA report, basically our message could boil down to this very short phrase: we know what the problems are, we know how to start fixing them, and now we have to justice do it. Thank you.
Hello. Oh, hi. Thanks, Melina. Once again, just an excellent presentation, and lots of interesting things for us to think about going forward. We do have a few minutes for questions, so There's a mic here, but I can run around as well and get you this mic. So questions for Melina?
No, I was only able to bring 20 of them, but it is available at the CBA website, or you can email the CBA office and ask for a copy.
Should I go ahead?
Go ahead.
Thank you very much for a wonderful talk, very inspiring, and I can tell your commitment to the cause is evident. My question is this: you talked kind of around the following, but maybe didn't quite state it. I mean, unequal access to justice isn't a legal problem; it's a social problem, and you did talk about some of the social consequences. Mm-hmm. But one of the things that says to me is that maybe more progress would be made more quickly if, for example, organizations like the CBA were acting in unison with not lawyers. I'm a lawyer too, so it's not lawyer bashing, but I certainly know that many people, wrongly I think, but many people interpret activism on the part of lawyers in favor is self-serving. More money to the lawyers will we know that's not the whole solution, as you've made clear, but why not associations of social workers? Why not activists? I mean, one of this whole sets of issues which suffers from inadequate access to law, which is the way I think about it, rather than access to justice, is, for example, the environmental movement. A whole lot of really great things could be happening, and they're not happening because the law does not serve that whole set of interests well. So do you think about that? And maybe I've just missed it, and the CBA is working with all sorts of different disciplines. Thanks.
So I agree with you completely that this is an area that we haven't done a very good job at. We did, the Canadian Bar Association nationally, when we were working in a sort of really focused way on the legal aid issue leading to the litigation that Jennifer mentioned, we actually did set up a national coalition of advocacy groups, the National Anti-Poverty Organization, various we're working a little bit with health and social workers who are working on sort of the social determinants of health, and they definitely understand the role of law and unresolved legal problems and that. So we did do that for a little while. It's something because we're the kind of organization that we are, we don't tend to ally ourselves with organizations outside of the law very much. But certainly what we recommend to the CBA in the report, because this is a report from our committee to the Canadian Bar Association, so we say that in fact the CBA should have a leadership role in doing that. And when I talk about the CBA nationally getting involved in public engagement, that would obviously be a first step. And we say that specifically as an immediate action. So identifying our allies generally on the issues of access to justice, and then it may be more focused in specific areas. So for example, in terms of building legal capabilities, we'd be working in particular building allies within the school system and other kinds of education providers and so on. And then in terms of the overarching issues, it'd be a much global, much broader coalition. And certainly my sort of vision, I can say this because I'm not the chair of the committee anymore, so I don't have to undertake it, but it's certainly the message that I left with my vice chair who succeeded me, is that if there's one thing that the CBA should do, it's exactly that. And I'd love to see the day where we have a platform that's agreed to by the whole range of groups within Canadian society. In BC, I can tell you that the CBA branch, has worked very hard, especially, for example, with chambers of commerce and other groups that you wouldn't immediately, the municipalities and other groups that we wouldn't immediately think about as being allies on this issue. It's taken a while to nurture those relationships, but there's actually been a very open door and a very quick understanding of why it's important to the community as a whole. And so I couldn't agree with you more that that's the way we need to go.
Other questions? Okay.
So they are a very important part, and I think that our greatest challenge right now is that fragmentation, right? And that it's not obvious to a lot of people, especially if it's the first time they've had a legal problem, where to go, what kind of assistance they need. And so what we focus on in the report is really developing, when I say the front end of services, so that people would just have one door to go to or one number to call, one kind of portal that everybody would know about in the way that we all know about the clinic, the health clinic and or emergency room, right? Depending on your view of what situation you're in. And that we really need to invest in that because it's actually quite a high level skill to quickly diagnose someone's problem and legal problem and point them in the right direction and then do the right kind of follow-up. And that's something that is, I do understand there's sort of a triage model that's starting to be developed at the Superior Court here in Alberta. And there are various other areas that are developing that, but there isn't still an overall one in any jurisdiction. Community legal clinics used to really play that role in BC. It's hard to talk about the country as a whole, but in BC, or in Ontario still to some extent, you could go to the clinic and sometimes they would tell you, okay, it's not a legal problem, but here's the number of someone to call, or do you want me to call? It was really what they call sort of a warm referral, right? It was like not just giving you the number or the website, but actually calling for you, making sure that you were able to take that first step, that you felt like you knew the right thing to say, or to actually someone to kind of lead you to that. And so I think we really need to be developing that. And all of the providers that you talked about are a part of that. And I think certainly law librarians are really an undervalued and unrecognized part of that work. But we also need to broaden it to other kinds of professionals, the way I was talking about.
So I have a question about I guess what I would frame as the theoretical underpinnings of the report. I would love to believe that we have a right of access to justice in Canada, but of course we have a less than fulsome embrace of that right by our courts in cases, I'm saying this not so much for your benefit, but yeah, the CBA case, the Christie case that we study in first year constitutional law, et cetera, et cetera. So I wonder whether you had any debate amongst the committee about whether framing access to justice as a right was the way to go, or whether framing it more in terms of cost-benefit was beneficial. And I know you talked about some statistics that do lead to that sort of analysis. So $1 spent on legal aid is $6 saved down the road. Did you have any debate about what might be the best way of trying to articulate the theoretical underpinnings of the work?
Mm-hmm. So we start from the proposition, and this is established CBA policy since the early 1990s, that essential legal services are public services that are covered by the Constitution. As you just mentioned, we haven't been able to get a court to agree with us yet on that, and I still have nightmares about all the cases I've lost in that area. But none of them are complete losses, and there are still a few doors or windows or cracks open for us to go forward. Certainly it's quite interesting because judges, including the Chief Justice of Canada, when they're outside of the courtroom, talk about a right of access to justice, but have been less willing, at least in the cases that we brought forward, to recognize that. So we've really framed this report, although it's based in the right of equality more broadly, and building that in a very fundamental way, we really base our arguments more on the policy side. So doing this because it's a good thing. It's a good thing because it makes the justice system work better. It's a good thing because we know it saves money. All of those. We know that inadequate access reinforces poverty. So very much those kind of broader arguments rather than, while at the same time leaving room this possibility of having a right of access to justice. But I think we felt like, people know what the CBA thinks about that. We didn't really need to frame our report in that way. And also, of course, there's the whole international arena where the right of access to justice has a much broader recognition. And we argue that in every case we can, but we haven't really had any uptake on that in Canada either.
I guess I'm being allowed to ask a second question. I'm greedy. I love this topic. But I was sitting here trying to stifle my more conceptual side. and Jennifer's question has, I think, given me permission maybe to say a little bit about that. I mean, I think it really would be advantageous to think a little, or to articulate, you may have done all the thinking, but perhaps it isn't in the documentation, to articulate more clearly what that right is that you're claiming. Because to my mind, it's a socio-political ideal. It's like when we all argue all the time about the rights that aren't yet recognized in law. It doesn't mean that they aren't rights, but we're arguing for democratic rights, political rights, moral rights, ethical rights. And I don't think one should shy away from that, because otherwise it's confusing for people. And then you feel like you failed because, no, we don't have the legal right to it yet. But, I mean, when you think about the importance, and I really love the quote, I just had a chance to peruse the document, the quote about we're law heavy but legal resource light. I mean, it's absolutely true. And so if you think about what that means, that we've got all this law that does govern so many aspects of our lives, and I support it too, but if we don't have access to the protective aspects of law, then that's an oppressive force in our lives, right? It's very anti-democratic. So I think, for me, greater clarity on the democratic values, the fairness, the moral values, and then let's bring the systems along. And whether we're going to ever get what you want out of the Supreme Court of Canada, actually, who cares? Because we could solve it in other ways.
So we do very briefly make the argument about the relationship between the courts and democracy, and the fairness of the system as one of sort of 6 arguments in support, but it's not by any stretch the most developed. There's no question in my mind that the Section 15 right to equality and the talks about equal benefit of the law and equal protection of the law clearly say that. And we are continuing to try to bring individual legal aid right to counsel cases to try to get that recognition, because there's never to date been a full Section 15 argument in that context, right? It's all been done under Section 7, the right to life, liberty, and security of the person, other than in a few cases, family law cases, where it's been an unrepresented litigant says, by the way, there's a right to equality, so no argument, and of course, very easy for the judge to, turn it down. So my view is that's never been really properly before a court, because the CBA case, the systemic case, got shut down so quickly. We do have 2 cases we're pursuing in New Brunswick right now. We did try to bring a case in BC about 2.5 years ago, but we got through some of the initial hurdles, but then the litigant settled her case and didn't really want to pursue it. And so that, the problem with individual cases is exactly that, right? The government either tends to settle them and moot them out because they don't want the precedent, or the litigant just isn't able to continue, even in sort of a representative capacity in an individual test case. So it's not that we've abandoned that in any way. It's just because we're trying to create a dialogue. Sometimes talking about rights helps to frame the dialogue, and sometimes, especially when you're speaking to governments, it tends to shut it down. So it's kind of a bit of a choice.
Got another question.
Okay, so my question is just on the idea of regenerating publicly funded legal services and the implementation of national legal aid benchmarks. And I was wondering if you could speak to countries that Canada can look to for guidance in this area.
Well, actually, we don't even have to really go outside of Canada. In British Columbia, which is the province that I have the most knowledge about, our 1979 Legal Services Society Act actually had standards in it. So it said, in these kinds of cases, you have a right to legal aid if you're eligible on a financial basis. So there's actually already a pretty strong basis in Canada historically for that. There certainly isn't one country that I would say they have it right, and we could just take that. In fact, what's happened is we've moved from the 1970s, when legal aid was first developed in an organized way, growing out of the pro bono movement, to a time where we had guaranteed standards. But what happened is that legal aid providers were continually going over the budgets, because the demand was not something that they had any control over, just the same as we do with our health budget, right? We can't say, oh, well, we're only going to have 600 family law cases this year or whatever. What happens if there are 800, right? So governments, understandably, had a couldn't deal with these legal aid organizations always going over budget. So what the tendency to do in Canada and in other countries is to get rid of these standards and sort of guaranteed levels of service and just saying, okay, well, you have this fixed amount of budget, you figure out what the priorities are and how to provide them in the most cost-effective way. And so that's the direction we've moved in, and because of that, we have a real patchwork across Canada in terms of what's available. And in some provinces, including mine, it really changes from year to year. So people don't even know whether to apply because, last year they were turned down for a family law matter, but then in the next year there's a little bit more money available. So it's really, we feel that that's a completely untenable situation and that it would not take very long to come to an agreement about what are the essential areas where legal aid should be provided to people. And in fact, we have had initial discussions already with the Association of Legal Aid Plans, which represent all of the legal aid providers, the formal legal aid providers across Canada, about how to work with them to try to establish those standards.
And another question, Heather?
Hi. As articling students and young lawyers that are just starting out, how can we, I guess, sell the idea of implementing access to justice initiatives to our principals, to our superiors, in terms of how do we sell it to them? How do we convince them that this is a good idea for us?
Mm-hmm. Well, I guess the same kinds of making the same kind of arguments that I've tried to make today. I think that in addition with law firms, and I think that certainly this is something that I've learned from Jillian, there's really been quite an open door to understanding that the profession has a special responsibility over and above what other people, other members of society have to ensure that there's access to justice. And so there has been a growing number of law firms that ensure that they do a certain amount of pro bono work and so on. And so I think that's one way that I know that it's possible to make those arguments. I think the other area that I would really like to see expanded, and where I think, again, the CBA may be able to support people like you who want to bring these arguments forward, is what about people who can afford to pay a little bit? And, it's this concept of low bono. What if we had, we were allowed to charge less to some of our clients based on their needs? And I think that will also help to go a long way. And there are good and valid reasons for doing that rather than completely pro bono. Other than that, I think it's really kind of, just bringing the information forward. If you feel comfortable in your session, just having a discussion group about what's in the report and getting the action, rather than, saying that this is something that absolutely has to be done, and have a discussion about, well, if we were going to do 3 things as a law firm, what are we prepared to do? And I think it's a really good moment to try to do that, because there's so much discussion, because we have, Supreme Court of Canada judges going around, saying this is an important thing. I think now's a really good time.
Hello. Hello, Melina. How are you doing?
I'm good. I haven't seen you for ages.
I know. We miss you. We miss you on the committee. I just wanted to respond to that. And Heather, it's a good question. Certainly in Alberta, I think it was more of an awareness issue amongst the firms as to the fact that students were really wanting, law students and young lawyers really wanting to do this, and giving them the opportunities and the knowledge of what is out there for them to do. I think previously in Alberta, pro bono and doing pro bono has been defined by either volunteering with CLG or with ECLC in Edmonton, so you're looking for that clinic, you're looking for something like that, which was really not a firm project or model that the firm itself could buy in from a management level. And I think one of the things that Pro Bono Law Alberta has been trying to do throughout the province is to get that firm buy-in that we see coming through the United States and through the Toronto larger firms, where it is part of the package with the law firm. I mean, the major law firms now all have significant pro bono policies that they are trying to implement throughout Canada. Gowlings was just in the paper today. They estimate they have, throughout Canada, have donated $3 million worth of legal services to pro bono activities across Canada, which is outstanding, right? Mm-hmm. And what you need to do is go to the firm and say, we actually have a project for you. And I think even a small firm, if you went to the management of the firm, whoever that is, your principal or mentor or whatever group, and said, I want to do this, and I want you to endorse it, and I want to do it as a firm project, you're actually going to get some buy-in on that. It's a huge, when I do the business case argument to law firm managing partners, it's a business case. It's a recruitment retention case. It's keeping your associates happy and engaged so that they will stay with you and not leave at 5 to 6 years out, as we know is happening. So I think there is that ability, and I could say, and I'll put my organization out there, if you're with a firm that doesn't have a pro bono project, or going to a firm that doesn't have a pro bono project, and you want to engage in one, just give Pro Bono Alberta a call. And we will work with you and with the management of the firm to actually create a program or a partnership that actually works for you. So, but I don't think it's an issue there as that it used to be, because I think it's just become so more popular as a result of the work of the CBA and the National Action Committee. But primarily because of the movement and the push from Toronto and the United States and New York firms and UK firms going, we do this, and if you want to compete with us, you're going to have to do with it.
So I just, in addition to what Jillian said, I think, the other part of the conversation, I support, and obviously Jillian I would defer to her on matters of pro bono in any way, but also, consider raising some of the other issues that I've talked about today. So how can the law firm, contribute to justice innovation in terms of how they provide their legal services to all customers, because that is part of how we're going to improve justice, not just through pro bono work, as important as it is. What about is there something that the law firm is prepared to do in terms of championing legal aid? A lot of the large law firms, if they came together and put that message forward, that would really carry quite a bit of weight, for example, too.
I think Mary Ann's left, but Kim Ho is still here. And I wonder if we got all our law students to ask firms that they're interviewing with an access to justice type of question in their interview. I hope that wouldn't be a killer and that everybody would still get jobs. But, I think that's something where we could kind of combine efforts systemically, and maybe in the sessions that you do, preparing students for job interviews with firms, we can start thinking about infiltrating it at that level, or maybe infiltrating is too strong a word, but
I was going to say, whenever you start talking about infiltrating, I feel really good. I think that's going in the right
we're
direction.
all about the infiltrating.
Well, thanks, Jennifer. Have I missed anybody that had their hand up for questions? Well, I think I speak for all of us when I say that it's been great to have Dr. Buckley with us today. If you heard her this morning, it was a wonderful talk, and again this afternoon. I'm going to have Ellie Carlson come on up. Do you want me to say it? Okay, I will keep speaking. We want to thank Melina so much for coming to us, and appreciate all of your time.